Good afternoon, everybody, and thank you for joining us today in this session where we're going to have a look at the A-level and GCSE results and appeals, particularly from an independent school's perspective. So today, the focus of the session is very much going to be about planning and risk management with reference to your post-results support, which is something I'm sure you are turning your minds to now. We'll have a look at this year's appeal arrangements specifically. It's an unusual year and a bespoke set of appeal arrangements. And of course, the interplay between those appeal arrangements and various other rights that parents and pupils have and obligations, of course, that schools have as well, in terms of parental complaints and subject access requests, which many will remember were quite a theme of last year's arrangements. So here's some useful guidance. I would be very surprised if we managed to reach this point in time where this guidance was not absolutely something you were familiar with back to front by now, but useful, I think, as a reminder, because once we get going with appeals, it will all come back to this crucial guidance. So we've got the Ofqual guidance for heads of centre, heads of department, and that's the detail of the teacher assessed grades. Supported, of course, by the JCQ guidance, which was quite comprehensive. The objective judgments guidance, don't forget about that. That could be quite crucial this year. And I think that we know issues around special consideration and those types of reasonable adjustment access arrangements that feed into disability discrimination type issues. That guidance is likely to be a feature and a factor in that. And then, of course, we've got the appeals guidance, which was more recently produced by the JCQ as well. There's various other bits of supporting guidance and documents that the JCQ and the exam boards themselves have produced, so it is worth familiarising yourself with those as well. Of particular note, the JCQ has produced a number of important and helpful templates. Of course, many of you will be using the centre policy that's based on the JCQ template, and the JCQ has produced a template form for pupils to request appeals, which hopefully sort of breaks things down. So I think it's helpful when we're thinking about what we do next by looking at actually what is it we are trying to achieve. Now, of course, you will have your own views about this, but what I would suggest, and when I think about it, I think that what you're trying to achieve in terms of your post-results support is that, of course, you want to provide an excellent service for pupils and parents, because that's what you do day in, day out. It's how you operate and absolutely all about your business and reputation. But you're also looking to maximize outcomes. So you want to make sure that the results and how you respond to any issues around the results ensure that you're getting the absolute best results for your pupils. And finally, and I think this is an element that's worth remembering, and of course, very, very much a lawyer perspective, but I think is probably within the range of considerations that are really quite important. It's about mitigating risk. We will remember from last year that because the arrangements that were made were to some degree hurried, necessarily so, they departed hugely from the normal exams years. There was a lot of uncertainty and quite a bit of confusion, and I think what we saw was a significant scope for things to go wrong and for you to come into conflict with pupils and parents around those arrangements. So thinking about those risks and taking steps to be able to manage and reduce them where possible is important. So I propose a three-step plan. And again, I would just caveat that by saying you'll have your own. But what's important here, the key message, is to have a plan. And I would suggest to you that identifying errors and signs of dissatisfaction early, forecast and surveillance, as I call it, is a really helpful part of planning, because you will already have gone through the process of assessing grades. It should be reasonably clear to you in a number of cases where grades are likely to come as a disappointment to pupils and to parents. And those are the sorts of cases where perhaps you can be taking early steps, whether that's to do the double check and to review your your records, your assessment records, and or just really to look in terms of numbers around how many of those you're likely to be dealing with, so that you can think appropriately about resourcing, or what are going to be some pretty tight timetables around post-exam support and appeals. So the next thing is timely and appropriate advice. I mean, this is really a standard for best practice throughout your dealings with parents and pupils. It's not specific to exam arrangements and appeals, but about, you need to be clear with parents and pupils about what to expect, about the school's approach, and actually what they can do and what you can do, so that everything fits together well. And you have the opportunity also to understand where the concerns are likely to come from, and perhaps even head some of those off in advance. It's also, and I should tie that back to the guidance, but very much a part of this year's arrangements, that schools will have robust systems for being able to clearly communicate how they've gone about assessing grades, and clearly communicate what the appeals processes are as well. And all of that is intended to draw out a dialogue between school, pupil and parents, so that actually you can identify and deal with as many issues before results are released as possible. That's certainly the intention of the arrangements. How that translates in practice is something that you'll all be sort of seeing firsthand now, and I've seen to some degree a mixed picture. And finally, take action. Where you have identified that there's a likelihood for issues to arise, and or parents and pupils do post results request reviews, etc. Don't miss key dates. Make sure that you're acting upon it, because ultimately, you might have a pretty limited window to be able to take action, which will more or less completely correct any error. And when you miss those opportunities, the consequences can become considerably worse, almost on that sort of sliding and escalating scale, as it were. So taking action at the right time is going to be a really important part of managing risk. In terms of planning, I've got some thoughts here for you about some of the key messages for the purposes of planning. And key dates obviously is an absolute must. You need to know exactly what needs to happen and when, so that you can ensure that you are taking that timely action. We've talked about clear guidance for parents and pupils. I think that it's unavoidable that that's something that you need to do as part of this arrangement, but also the benefits of doing so as well, I think, are abundant, as I've alluded to. Be ready to provide effective post-results support. So what precisely are you going to need to do come results day? Some of this will be standard fare for you in terms of being there to be able to support pupils with understanding what their options are, contacting universities, advice about deferring for a year, for example, resits in the autumn, that whole range and menu of options. But that effective advice and support can go a long way to managing and redirecting some of that initial disappointment that some students may feel. And of course, the appeals process will be part of that, but won't necessarily be appropriate for all students and pupils who are feeling dissatisfied with the outcomes. One thing to mention about this year's arrangements is, whilst we'll talk about the appeals arrangements this year, there are some extra limbs, if you will, to that. So one is the exam procedure review service, and that's a service actually operated by Ofqual. It's an administrative review that considers whether awarding bodies rather than schools have followed their procedures. So in effect, if a pupil or parent is dissatisfied with the way an appeal was handled by a board, they might be able to apply to the EPRS, and sometimes the school might want to support them in doing that. So don't forget about that. It could be an important part of the arrangements, albeit probably is not of very broad application. Judicial review, I mean, this is the legal option, if you will. So just worth remembering, and I don't think there's a huge scope for this to be an issue for you this year, but it is worth remembering that the exam boards, the awarding bodies, and of course Ofqual itself, they are they are bodies exercising public functions. They're susceptible to judicial review, and judicial review is a legal review of decisions taken by public bodies. I mean, I won't get into the ins and outs of that, but again, it's worth bearing in mind if you should find that you have one particularly contentious case that's gone through a number of processes already without resolution, there are sometimes other options for being able to move those things forward. And of course, we come back to the point about mitigating action. Sometimes the more the school can do to support parents and pupils in the action that they take and to direct energies and focus into those types of processes, the more you're doing to actually reduce the risks that you're facing. And just to give you a little feel for the risks, when I talk about risk, if a parent or pupil is dissatisfied, it may be that they say that there is something that has gone wrong that might be legally actionable. It could be a breach of contract. It might fall short of your duty of care to the pupil that could give rise to a claim of breach of duty and or discrimination, some of which will be actionable through claims in the civil courts. So these things are reasonably high stakes in some circumstances, and worth bearing that in mind. And this sort of brings me on to the next thing, a consideration here, related issues. So third parties, bear in mind that whilst you may have your focus on one particular pupil that's asking you to look again at your assessed grades in the process that was followed, that you might identify issues that are of broader application. Equally, you might still be going through a process of external quality assurance with the boards, who might also identify something that is that is an issue in your process, in the way, in your approach, therefore that could have broader application as well. So malpractice, very much a feature of this year's arrangements. It was last year too, and I think kind of got forgotten about a little bit because everybody was grappling with the sort of the central issues, and the appeals were quite complex last year in terms of what could and could not be dealt with. So malpractice this year will consider different issues because the nature of the arrangements was different. So things that might constitute malpractice this year might be if you selected evidence for assessing grades that you didn't feel was reliable. It would have to be a reasonably stark case, I think. If there's evidence that you've given too much assistance to pupils, that could be an instance of malpractice. Failure to properly authenticate a pupil's work, over-direction, and or it can also be pupil malpractice, insofar as you may have found that you were coming under huge pressure around relying on certain evidence and or pushing towards certain grades, and that's something that the exam boards could treat as malpractice on the part of the student. And of course, they may also have produced work that was not authentically theirs if it wasn't done under supervised or controlled conditions, and that again could be an instance of malpractice. So worth bearing those things in mind, because you still have the same duties in terms of reporting malpractice to the awarding bodies immediately. Failure to do so of itself can be malpractice, and that would be subject to a whole separate process from the appeals arrangements. Except, of course, where the boards direct that it can be subject to an appeal, perhaps as a precursor, which I think we saw a little bit of last year. So other related issues, we've said complaints and subject access requests. We're going to come on to those a bit later and talk about some of the practicalities for this year. I've mentioned the risk of claims, so don't also forget about your insurance. Most of you will carry insurance that will cover at least some of those claims and risks. It's usually a condition of cover that you will report circumstances that give rise to could give rise to claims, and make sure that you're getting those reports in so that you don't give your insurers an opportunity to wriggle should you later find that you're subject to legal action. And I've mentioned already, making sure that you have plans to have the resources in place to be able to respond, and in a timely way, to a significant number of different challenges that you will have come results day and the days and weeks that follow. Okay, so an overview of this year's appeals arrangements. I would imagine this won't come as news to anybody, so I will go through this swiftly, but do raise any questions that you have as we go. So it's a two-stage process, principally, the review and appeal. Review is a school-led process, and we'll talk a bit more about that in a moment. Any pupil can seek a review and appeal regardless of the outcome of their review. So if you review and you say, nothing to see here, everything's fine, that doesn't prevent the pupil from saying, I want the boards to look at this. And again, we'll look at the precise grounds that they can use when asking for a review or appeal in just a moment. So the review is mandatory before the appeal. It's something that you have to check, and this is a sort of a check and a balance to try and reduce the workload on the boards in terms of asking schools essentially to check that you got it right before the awarding bodies are actually bothered with an appeal. Now, one of the important limiting arrangements for this year, and something that might act to actually reduce the overall numbers of appeals, is unlike last year, student grades are not protected. And what this means, of course, is that they can go up, down, or stay the same. And it's important that pupils understand that when they're seeking reviews or appeals. And of course, they have to consent as well and provide grounds. Schools would need to submit any appeal to the exam board on behalf of the pupil, but as the JCQ template form shows, actually the onus is on the pupil to explain what their particular grounds of appeal are. Now, it's set out in fairly straightforward terms in terms of what do you think went wrong and what difference has this made to your grade. But nevertheless, I think that's helpful to schools in that it is whilst you will be compiling the paperwork and submitting it to the board, it will be the pupil that needs to tell you what their particular appeal is. And the boards can reject an appeal that they say does not meet one of the grounds of appeal. That is a possibility this year, albeit that a decision to reject would be subject to EPRS review. So I've mentioned here that EPRS, it's proposed that pupils, I think it's now been decided that pupils or centres can apply, and which is the better option will depend on the particular case. As I say, there are benefits to schools, I think, sometimes in being seen to actively support pupils going through these processes of review and challenge. And ultimately, if there is an error that's to be discovered and corrected, that will benefit the school as well as it will benefit the pupil as well. So those things need to be considered. We mentioned the key dates, so just a couple, which I'm sure are already firmly in your diaries, but requests for priority appeals reviews have to be made by the 16th of August. So that gives a fairly small window between the 10th and 16th of August. And a priority appeal is an appeal that where a university place essentially hangs in the balance. Everything else is non-priority, and any review has to be requested by the 3rd of September. So for priority appeals, the reviews actually have to be completed by the 20th of August with a 23rd of August deadline for an appeal, whereas for a non-priority review and appeal, then you have until the 10th of September to complete your review, and the 17th of September is your appeals deadline. Okay, so there's a few things this year that are sort of mandatory, and we'll just have a little look at those. So schools must have a clearly documented process and resources for reviews and appeals, and there'll be a range of different approaches. It's not prescribed this year in terms of specifically how you go about that. But again, it comes back to that clarity of communication with parents. So you need to make sure that a pupil will know precisely what has to happen come results day if they want to request a review and then subsequently an appeal. And that comes back to the clear communication in advance of results. And so don't forget about that. That's something that you need to already probably have communicated about, or certainly be gearing up to do so in short course. You must also have ready access to materials needed by the pupil to assess and decide whether to request a review. We'll look at precisely what that is in a moment, but I think you've gone through your assessment process, therefore you know what information you relied upon, you know the decisions that were taken, how they were recorded. It would be helpful to the school, I think, to manage the administrative burden, but also to be able to respond to this particular requirement, to have a record system, a record keeping system that's easily accessible to you. So just worth giving that some thought if you haven't already done so. And then, of course, you need to keep a record of all reviews undertaken and complete a review before any appeal. In terms of keeping the record of a review undertaken, it's worth just mentioning that if you've gone through a process where you establish there are a number of cases that perhaps are more likely to be subject to review and appeals than others, and you've already done some double checks, you record that can constitute your review. So that obviously, if you identify any issues, you're able to correct errors prior to the issue of results. That's going to put you in a better place with pupils and parents, and of course, reduce the burden post results. But also, if you don't find an error, and once the results are released, you do indeed get the request for a review, the fact that you've done it, unless there's anything new raised in the review request, means that you can simply confirm that you've done it and what the outcome was, and that's going to save you some time. So absolutely worth thinking about. Okay, and what you can do is continue checking for accuracy, as I've mentioned, correct errors prior to results. Again, I think that there are real benefits to that. I do appreciate that many schools will either have ended their terms on Friday or be looking now towards the end of term at some point during this week. So I may be limited for you to be able to do that, but as I say, worth thinking about. And you can also, and there of course are balancing considerations here, but you are able to share with pupils in advance the assessment evidence that you've used, which you should have done already under the terms of the guidance, but you can share the specific marks that were given against any particular assessments that were used. You can share the centre policy and supporting documents, any details of variation to the evidence basket based on things like special circumstances or reasonable adjustments. Access arrangements, and of course the specifics of any details of special circumstances that you took into account as well. And all of that is designed to, as I say, facilitate a dialogue, an early dialogue that will lead to the identification of errors or failures to follow procedures in accordance with centre policies. So the centre review, the grounds are only two at this stage: that the school did not follow its procedure properly and consistently in arriving at the pupil's results, or it made an administrative error in relation to the result. Now, this is a really key point because there is no consideration of academic judgment by the school at this stage. And actually the guidance suggests that there should not be any consideration of academic judgment. And that's worth just bearing in mind when we come on to look at complaints in a short while. Now, when you come to think about the exam board appeal, the grounds are slightly different. So this again would be that the school did not follow its procedure properly and consistently in arriving at the pupil's result. Now, what that means in practice, you didn't follow your procedure. So it might be that you didn't, there was something about the way you approached assessment of grades that wasn't in line with your centre policy. So that might be one element of that. It might be that some bias has allegedly crept in. It might be that you took a different approach to special consideration that wasn't necessarily in line with your policy or guidance. So those types of things will fall within that ground. The more crucial ground, and I think where we see the greatest capacity for the possibility of appeals here, is that the result reflects an unreasonable exercise of academic judgment on the part of the school. Two limbs to this: first, in selecting the evidence for the evidence basket, and the second part is actually in the assigning of the grade. So it could be either or both, but it's those crucial judgments made by staff about those matters. Now, that sounds like a hugely broad ground of appeal that's going to be very tempting to pupils and parents. In reality, this is not quite the panacea that it might seem from their perspective, because the boards are not going to be considering any alternative judgment that could have been made. So if a pupil or parent wanted to make a case to say, well, if I looked at these pieces of evidence, I would take a more generous view and I should have got the A rather than the B, that's absolutely not going to be how they're approaching it. It is a much narrower consideration for the boards, where they will be looking purely at the judgment that was made and the evidence against which it was made. And they will be asking the question, is this a judgment that somebody could reasonably come to? As in, is there a sufficient connection between the evidence and the grade? And it is only those cases where they say no professional could reasonably have come to this view based on this evidence, where they would uphold an appeal and look to correct the grade. So I think the number of successful appeals on that ground are likely to be pretty slim. And of course, it will be interesting to see how many pupils and parents are prepared to chance their arm with appeals when they know that their grades are not protected as well. So, of course, finally, as well, the awarding organisation made an administrative error. This is something that essentially the exam boards have issued the wrong grades, and it should be probably immediately identified and corrected by the school without or rather without substantive involvement of pupils or parents in that process. So I've just listed out here some evidence that you're going to need to think about in terms of putting forward any appeal to the boards. And I've listed out, you'll get a copy of the slides, so I'm not going to go through step by step. But one of the things I do just want to sort of challenge you to think about again is the logistics, really. You know, if you are to be absolutely bombarded with requests for appeals, you don't want to be in a position where you are running around trying to pull together packs of evidence. You know, are you able to store them in such a way that actually you can pull it together really quite quickly? I mean, almost there is a standard body of evidence within this. You could perhaps almost have your appeals pack 50–60% compiled and ready to go for any appeals that are requested, is the possibility that you might want to consider. I know this year there's been quite a bit of concern and soul searching about the relevance and the importance of historical data when you're looking at your assessed grades. And one of the questions I've had asked of me previously is, if your historic data is significantly out of kilter with your assessed grades, but you can't give a compelling explanation for why that is, you know, what do you do about that? Because we know that exam boards expect you to take into account historic results, and we also know that boards are more likely to ask for evidence to support grades where your results or where your assessed grades are significantly out of line with previous years. And what's important to remember about this year, as opposed to last year, is that the scope for your judgments on assessed grades is very much more limited. So last year there was an element of forecasting, in as much as you were asked essentially to assess how a pupil might have performed had they sat the exam. And that's a much more sort of speculative exercise. And therefore, and we know, of course, with the proposal for standardization at board level based on the algorithm, that historical data was going to be a really sort of crucial part of that. And even when it was removed, schools had certainly had to take that into account very carefully. This year, the basis on which you are assessing your pupils' grades is on evidence of performance that you actually have. So you can come to a much more reliable, objective judgment looking at the work that you have before you. So in theory, if you've gone through a rigorous process around determining the most suitable evidence to use to assess pupils' grades, you've considered that properly, taken into account some of the exceptions around special consideration and access arrangements, and you've arrived at a grade that reflects that evidence, well, if it is out of line with historic data, absolutely, that's a quality assurance check. It's a sense check to say, is there a reason for this? Is there some sort of a failure within the procedures around standardization between departments, for example? Is it that actually the underlying evidence base perhaps was marked in a way that was more generous and wouldn't reflect the grade descriptors and exemplifications? But assessed grades really should have been arrived at having considered those grade descriptors and exemplifications. So ultimately, if you do the double check and the evidence absolutely supports the grade you put forward, then it's quite clear to me that you are not asked, in fact, you're asked not to adjust your grades by reference to historic data. It would be helpful to you to be able to put forward a nice, neat explanation that's going to make the exam boards feel warm and fuzzy, that you're not inflating grades. But fundamentally, if you don't have that explanation, but you're happy you've got the evidence to support your grades, then the exam boards are not going to be in a position to overturn those grades. So I hope that's of some comfort, and it's certainly, as I say, a question I've seen come up a few times now. So just getting into complaints, last year was, I think, this was a real challenge for schools, because the appeals arrangements were so narrow that the parental complaint was seen, I think, as the sort of collateral attack on assessed grades and the way in which parents could bring pressure to bear. Of course, there were some valid, or at least legitimate, complaints as well that consider broader concerns around, I don't know, the quality of education across the course, those types of things, which absolutely you will see some of this year as well. And those are complaints that need to be dealt with as usual. Now, this year, because the appeals arrangements are much more generous and professional judgments are up for consideration, that is likely to reduce the instances of the complaints procedures being used to consider those types of issues. And if you will recall, I said earlier that when you are at the review stage, you should not be considering matters of professional judgment. So it is right, in my view, to actually refuse to deal with a complaint that would address any of those issues whilst there's a review ongoing and a possibility of an appeal. So what I would suggest is that that you have a look at your complaints procedures and that you ensure that you are signposting that there's a review and an appeals procedure to consider accuracies and the accuracy and outcome of grades, and that way it doesn't act as a sort of a blanket exclusion of those issues from the complaints procedure. But what it does is it points pupils and parents in the right direction, the right procedure that's going to deliver the outcome that they want, which is, of course, an improvement in their grade. And I think if you had a mixture of concerns raised by parents, but one of the fundamental wheels of that was that they were unhappy with the outcome, I think it would probably be appropriate to park the complaint as a whole at the informal stage and wait for the outcome of the review and the appeal. But just be careful to ensure that your complaints procedures give you the flexibility to do that. And all it requires, in my view, is that where you have timescales, rather than set out absolutes in terms of we will get through the informal stage within 10 days, add in the word usually. And then, because you've signposted the appeals procedure, that gives you the flexibility you need to be able to say, we're going to park this for the moment, go through the appeal, see where we get to with that, and then we can do a stock take of the issues you still want to be considered under the complaints procedure, if any. And that should help you to manage the competing sort of drain and requirements around resources, and also the different timescales that you've got, and hopefully also reduce ultimately the numbers of complaints you're being asked to deal with. So, as I've said, just breaking down how you approach any complaint, because the other aspect of this is sometimes considering a parent's concerns can lead you towards identifying a problem that you might be able to correct if you identify it quickly enough. So sometimes you might want to actually look at a complaint, but think about what is the complaint, what outcome is sought. As I said, if the outcome is an improvement in the grade, there's only one way that's going to come about. So they need to go through the review and appeals process. What does your policy say? I've suggested a couple of minor changes you can make that I think will give you the flexibility and the facility to be able to divert those types of issues away from the complaints procedure. Fact finding and mitigating action I've mentioned. Just bear in mind, if there are concerns raised, are they things you actually do want to consider investigate so that you can take that action to correct any errors? And then ultimately, when you are dealing with complaints, think about the usual things. There's lots of senior staff who are involved in the assessment of grades, even at the level of sign-off, who then ultimately you need to consider whether they have the necessary objectivity to be able to deal with complaints, where they are usually the designated person to deal with it, say, under the formal stage, for example. And competence, of course, where you are saying, well, actually, perhaps the head of centre or head is not the right person to deal with it because they don't have that objectivity. Who else can deal with it? Who would have a handle on the detail to be able to direct a sufficient and appropriate investigation and to consider the issues? So I'm just going to hand over to my colleague, Vicki Bowles, just to talk to you now about subject access requests, which again are another issue which I think we saw a lot of last year. Over to you, Vicki.
Thanks, James. So we're going to talk, as I'm going to talk about subject access requests, as James has said, but one thing that we are hoping with this year's process is that, because there is a package of information that students are essentially entitled to when they're launching their appeal or their review, their request for review, there's less scope for them to make a subject access request for information that's likely to be relevant to their appeal. Because ideally, and in most cases, I would have thought in the vast majority of cases, the information that you've already got ready to go, that lists the evidence and what you've based the grades on and all of that information, is all they actually need. So they don't need any additional information from you for which they would need to make a subject access request. However, that will not stop pupils and parents, as we know. They do make these requests, and some of them will make them just as a catch-all and a just in case, and because they don't really understand the difference in the regimes, etc. So points to remember: a subject access request doesn't have to be in writing. So any conversations that you or any of your staff are having with pupils, if they're asking questions about their information and can they have copies of, can they see something, that's probably a subject access request. If they're asking for the evidence that they need to launch their review, you don't have to treat that as a subject access request. You can treat that separately. It's only if they're asking for something in addition to what they would ordinarily be provided with that you need to go through the subject access regime. And that's quite a sometimes that's a difficult thing to get your head around, because they're asking for information, but there's two different processes. And it's something that staff particularly need to be aware of, who are having those one-to-one conversations with pupils, so that they understand that this is the information that they will be given as a matter of course. And if they ask for anything else, then you need to make a note of that, and we need to deal with that under a different regime. Subject access requests must come from the pupil or with their permission, unless a pupil has specific needs that affect their understanding. So the average age of understanding is 12. So most of your pupils at GCSE and A level will have that understanding. So it has to come from them, or they have to give permission for their parents to make it on their behalf. And actually, if they're giving permission for their parents to make a request on their behalf, they have to understand the type of information that their parents might see. So if it is information that goes wider than the information that they're going to get about their grades, you need to consider whether there's something in there that actually they may not want their parents to see, and how much you might have to go through that with them so that they fully understand, okay, if you give permission for your parents to make this request, this is broadly what they're going to see. It's going to be information like X, Y, and Z. Are you happy for that? But make sure they understand what their parents are seeing. The deadline for a subject access request is 1 month, which is obviously longer than you've got in relation to the appeal process. So one of the practical tips for dealing with this is, I think if you are getting subject access requests alongside requests for reviews and appeals, there's going to be an element of triaging to see which of these subject access requests are for information that will be needed and which of them are for information that actually isn't needed, it's just of interest and or because a parent or pupil is gearing up to make a complaint outside of that regime and that's why they want that information. You may not be able to identify that immediately, but the key here is communication. So if you get a subject access request and you think, okay, this is for information that's not relevant to the review, so I'm not going to deal with it now, I'm going to wait until I've dealt with all these reviews, and I'm still going to do it in the 1 month deadline, but I'm going to do it towards the end. You need to be upfront with people and tell them and say, I'm not dealing with this because I don't think it's relevant to your complaint, but I will deal with it within the 1 month deadline, but you won't get it in time. And then there's a chance to have a dialogue if somebody really does think that it is crucial for their review or their appeal that they have that information. And we said there, pupils are already entitled to receive certain information, so we're only talking about requests for information outside of that they will already be given. If I could have the next slide, please, James. Perfect, thank you. So the approach to take with subject access requests, as we've just talked about, consider the context, seek clarity if you need to. We skipped ahead, so now I don't know which the second off the top of my head. Factor in risk management and mitigation. James has already talked about risk management, and you will know now which are your tricky parents and which are your less tricky parents and where you think you're going to get complaints. So analyse the risks here, look at the reasons behind the subject access request if you're told them, or if you can make an educated guess as to why someone's making a request, and prioritise accordingly so that you know that you can meet people's expectations but also meet their needs and your needs as well in terms of resources. Sort the priority from the routine information, so anything that's being requested that you think is relevant, as I've said, deal with that first and maybe leave the others later. And then finally, you can consider exemptions when you're looking at the subject access request element. There is the exam script exemption, so this operates so that a pupil can't get their grade ahead of time. So if somebody writes to you now and says, I'm making a subject access request for the grade that I'm going to get given in August, you can refuse to provide that until the date that they're officially released. There's also an exemption for information that a pupil has written in an exam, so in response to questions. So potentially you can use that exemption if you want to, but it's one of those ones that actually just because an exemption applies, it doesn't mean that you cannot release information. That's really important to remember. It just means that you can withhold it if you choose to. So if it's helpful to release an exam script that a pupil's written to perhaps demonstrate that their performance in a particular assessment was poor, as you've suggested, then you can release that to them and that's fine. If it's not helpful for some reason and you want to withhold that information, then that exemption is available to you. But it's worth considering whether you want to apply it rather than just applying it in a blanket fashion. The next common exemption is the serious harm exemption, and this is usually applied to things like safeguarding records. But essentially, any educational record that you hold about the pupil that you think will cause serious harm to them or another, if you release it to them, you can withhold that. And there's the third party exemption. So a pupil can't say, well, I want to know how my friend James did in the exam because I think I should have done better than him and he's got a better grade. You're not entitled to anyone else's information. You're not entitled to anything that identifies another person. So you can use that exemption to just cut out any of those types of requests. That's all I wanted to say about subject access, because we are quietly hoping that there will be less of them this year, but we'll have to wait and see how parents react.
Okay, so thank you, Vicki. That's really helpful. Now we're just going to move on to some questions. So it's the opportunity to ask anything that's that hasn't been covered. And I apologise. It's a relatively short session, this, and so necessarily quite pithy. I can see that we've got a couple of questions to ask about the particular arrangements for Cambridge assessment, and we can't get into the detail of that today, I'm afraid, but I'm very happy to follow up with you individually on those questions, which I will do after the session. So if anybody else would like to know anything about those arrangements in particular, now's your chance to ask the question, and we'll make sure that those are picked up and followed up after today's session. In terms of the other slides, apologies, the slides seem to be moving on their own. There we go. So I've had a question that says, what happens if the centre policy was written before the Ofqual JCQ advice was received and you might have done things differently in hindsight? Is it possible at this stage to review the centre policy or add updates? I mean, that's an interesting question. There's nothing in any of the guidance that would deal with this directly. And of course, the process that you will have followed is to have compiled your policy back in April and to have engaged with the JCQ and exam boards around that, so that any issues around that policy should have been identified and corrected. I mean, if fundamentally, I think what you're saying is, if as you worked through your practice, the way you approached assessed grades developed, if that was out of line with policy, or arguably so, is there anything you can do now to try and bring those back into closer alignment? And I think I would suggest that it probably no is the answer. I think anything that you do now to go back and revisit that policy and to make changes will suggest that you haven't followed that policy and potentially could be a ground for appeal. So it depends how marked the difference between your approach and your policy is. I mean, most policies I've seen were based on the JCQ template and written, therefore, in sort of pretty broad terms that set out principles rather than the nuts and bolts of your approach. So what I would suggest to you is look again at the policies and think about how you could, or how you would interpret that policy in a way that supports the approach you took grading. And if you cannot, then yes, absolutely, that might be more fundamental, and I think you should seek some advice from the exam boards about that. Because if there is, yes, I imagine you could probably correct a centre policy, but it might also entail going back and reviewing your approach to grading across a section of your pupils, perhaps even the entire cohort. So it's going to have some pretty big implications. So I would ask you to consider how weighty that issue is in the first place. So we've had another question. So if you have an appeal with the awarding organisation, can they ask for additional work as evidence? So the evidence they're going to be considering is the evidence on which you've made your judgment. So can they ask for broader evidence of that pupil's performance on the course? No, not usually. They will only be considering the evidence that you have, because the question they are concerned with, I mean, apart from a procedural argument, and I'll touch upon that in a moment, would be about the professional judgment that was actually made. And that means, this is the evidence. What were the school's reasons for selecting that evidence as the evidence basket, and whether or not that decision was something that seemed outside of a range of professional judgments. So they're going to be concerned mostly with what the school said. I mean, their hands aren't tied. So it is possible, if a procedural appeal was framed in a certain way, that they might want to consider why you didn't select other pieces of evidence, for example. But that doesn't mean they're necessarily going to want to look at it. That said, the guidance is very clear that you should be retaining evidence of pupil performance and that source, some of the source records as well, in terms of their actual work. And it doesn't have to be original. It doesn't have to be original documents, but you should be retaining a copy of everything, certainly from March onwards. so that you are able to produce that to the awarding bodies if they ask for that in relation to any appeal. Okay, so have we got much time left? So we've still got a few minutes. And another question, the JCQ appeal form seems to imply only students can appeal rather than parents. Is it fair to reject an appeal by a parent and insist this comes from the student? So what I would say about that is that, yes, the form is very much designed to capture the pupil's request for an appeal. It is, strictly speaking, the pupil's request. What I would say is that everybody has a stake, really, in an appeal going forward to the boards that covers the relevant points. So if a pupil is assisted by a parent, or a parent just submits that request, I mean, you'd have to make sure, of course, that you have the pupil's consent. So it would be impossible to act on the parent's say-so alone. But if a parent is helping them to articulate their appeal, then I don't think, I mean, I wouldn't recommend that was something that you pushed back against, because I think fundamentally what you want is for them to take their best shot, and for the exam board then to grapple with it and consider whether there is any issue. And ultimately, you know, if the school is found wanting through the appeals process, then a correction will be made, and that outcome will manage and reduce the risks that the school is otherwise facing. I appreciate you may still come into conflict with your pupils and parents about that, but I think everyone's got a common interest here in making sure that the appeal is dealt with properly by the board. Moving on to the next question. So apologies, but can a student ask to see their assessment scripts after the results day? So Vicki, I think it's probably one for you, isn't it?
Yeah, and the answer is yes. So a student can ask for anything at any point, as could their parents. So if they particularly want to see their scripts after the results day, they can make a request for it. And as I mentioned, for their particular scripts, there is an exemption. So you would need to decide whether you wanted to release that or not, but you don't have to, because you can withhold that.
Okay, and another one, I think, for you, Vicki. Can I just clarify that if a pupil parent asks for a list of information that's mixed together, review appeal information, then we can reject parts of the request and ask them to go through the appeals route, and the remainder can be a subject access request. If this is correct, then I thought with the appeals procedure, I thought all of the pupil data goes direct to the exam board and not to the pupil direct.
So yes, in terms of the it depends on the if you know that they are requesting information for the purposes of the deciding whether they want to ask you to make the review or the appeal, then I think the pupil needs to see that, because they need that information in order to assess whether or not they want you to take that action on their behalf. So yes, you would give it to them, and yes, you can take that outside of a subject access request. If they're making a request for other information, then it's about assessing, as I mentioned before, what you think they're asking for and why, and whether you think that will be relevant to that. Am I right, James, in thinking that the information should go to the pupil as well as the exam board?
Yes, so there's a minimum of information that you have to supply upon request, and as I mentioned, that is details of the evidence that was taken into consideration, the marks that relate to that evidence, the centre policy, and any supporting documentation, as well as details of any adjustments made to the standard cohort evidence basket, and details of any special consideration applied and how. So there is another subject access request question, Vicki. Can a pupil do a subject access request asking for details of their cohort's grades with their names redacted?
Yes. Well, essentially, anyone, you can make a subject access request and ask for anything. You wouldn't be entitled to that information, though, because a subject access request only entitles you to your own personal data. So it's only information that is about you. from which you can be identified and which relates to or is about you. Your cohort's grades are not your personal data. So they can make a request for that, and you can consider whether or not you want to release that information. I would imagine that you wouldn't want to, even with names redacted. But that would essentially be a decision that's up to you. There is no entitlement to the information. So it's one of those questions that it is actually completely up to you whether you want to give it or not. But there is no, they wouldn't be able to get it under a subject access request.
Okay. So the next question, I think we've still got 1 or 2 minutes. So how long does the assessment evidence have to be kept for? The answer is essentially as long as it takes. So certainly you need to hang on to it until the conclusion of any appeal. But bear in mind, as I said, the related issues. So for example, you might find that even this time next year, you could be dealing with a malpractice investigation by a board, and that would be relevant. So at least until the appeals are concluded, but bear in mind the capacity to need it for longer and make a decision both on a case-by-case basis and, of course, subject to your own records retention policies as an organisation. Next question, can we make the follow-up Cambridge questions available to everyone? Absolutely, we will. No problem at all. So can we advise timeframes for exam board appeals? We're still dealing with one exam board appeal in May this year from last summer. Yes, and I think we certainly saw last year that that the exam boards were prepared to be quite flexible about those deadlines. As we said, there are deadlines that have been suggested. So the 23rd of August for priority appeals and the 17th for all other appeals. We know that that's really just a starting point. Boards might refuse to deal with some appeals out of that time frame, but I think where they can be convinced that there isn't a substantive appeal there, they perhaps will be willing to continue to consider those. So no, I can't give you any absolute end date, except to say that I think that their willingness to deal with appeals will probably reduce over time. So there'll have to be a sort of an inverse relationship between how obviously valid the appeal might potentially be with a board's willingness to accept appeals out of time.